Selamun Aleyküm. This is my first time here in this beautiful country. Thank you for inviting and thank you for kind introducing Shiraz. It's a great honor and pleasure to be here and to be able to share some thoughts in this distinguished group of guests, legal experts, and friends from all around the world. So the question, what are the major challenges international arbitration in terms of energy disputes nowadays? So the short answer are there are many major challenges in terms of energy disputes. But I would like to mention some of them here. The first of all, we can call the major challenges the overpromise issues. Let me explain what I mean by overpromise issues. So in terms of investor-state dispute settlement, we know the states make meaningful promises to foreign investors in order to make a good investment climate to attract more foreign investors. Generally speaking, we can say the states may give too much to attract the foreign investors in order to meet the perceived urgent demands of increasing energy disputes, energy needs, as well as adopt the new technical equipment and knowledge. In this respect, the states may overpromise through their national energy law and regulations to make their legal environment and investment climate extremely friendly, attractive for foreign investors. However, in the other side, after foreign investors invest in these countries, because of these good and seemingly fixed commitments given by governments, states perhaps for a very good reasons change the rules of the games after it started. So then this too good to be scenario comes to an end and can give the rise to a dispute that becomes the subject of an investor-state disputes. So this is one of the major problem we can say, but the other one is, I would like to mention here, the reputation of the international arbitration as an effective and reliable means of resolving international disputes. I remember one of my professors from Boston University, William Park, he is also very popular in this investment arbitration and international arbitration world. He mentioned it very well. Like he said that the many politicians and journalists do not really understand what arbitration is all about. So, for example, a United States senator wrote for a very major newspaper, and she attacked arbitration with a question as, so what is wrong with American courts? So we can extend this question like what is wrong with Turkish courts or what is wrong with Pakistani court that we are looking for an alternative dispute resolution. So the answer is nothing. So nothing wrong with American courts if you are an American. But if you are in Turkish and if you are Pakistani. But if you are investing in any other countries as a foreign investor, and you might not feel the same comfort level if you have to go to lawsuit in local courts. And also, the other part of this issue, the globalization, continues to drive the expansion of international trade and investment. Disputes between the parties from different jurisdictions are becoming increasingly common. The problem becomes particularly important when one thinks about the fact that there are in the world still many countries without the traditional of judicial independence. The energy sector provides a worthy and significant example of this economic globalization. However, as in Turkey we say, every rose has its thorn. A consequences of that globalization in that the legal issues and the related disputes have been rising. The recent decade has been notable for a record of number of the investment disputes, especially in the energy sector. In this context, the investment arbitration has emerged as a preferred method for resolving such disputes, given its efficiency, flexibility, and enforceability. So the discussion about the reform issues in terms of the ISDS, we can say, I will say the reform is desirable, sustainability of the system, in order to strike the right balance between the states and the related public interest, on the other hand, the investors and the private interest. So that's all in this question I could say. I will say the short answer is yes. Yes, Turkey is considered arbitration friendly, especially if we think about the international commercial arbitration. First of all, Turkey is an important region for international and trade and finance. Istanbul has a great potential for arbitration proceeding, especially for Turkish companies who is investing in internationally, and also international companies who is investing in Turkey. The country has greatly advanced its arbitration legislation and practice, especially after 1980s. In this respect, it has become one of the arbitration-friendly countries in the world. In addition, Istanbul is the center of the trade. It's because of its geographical location. It allows you to go many cities with a flight about like 5 hours. For example, from Karachi, there is a direct flight to Istanbul about like 5 hours. And the other reason, I will say, we have the modern arbitration legislation, the legal framework in terms of arbitration governing, including both domestic and international arbitration. The Turkish arbitration law enacted in 2001 is based on ancestral model law on international commercial arbitration, provide a familiar and predictable legal framework for parties engaged in international arbitration. The other reason, recognitions of the arbitral award, Turkey is a signatory to the New York Convention on the recognition and enforcement of foreign arbitral awards. As such, arbitral award made in other contracting states, the convention are generally recognized and enforceable in Turkey, subject to limited expectation. Also, I will add, Turkey has established arbitration institutions, facilitates the conduct of arbitration proceeding. For example, İDAK, Energy Disputes Arbitration Center, is the first and only sectoral arbitration center focused on only energy disputes and operated as an international arbitration center. EDAC consists of the secretaries and the board of directors, the national boards and the international boards, the consultants and arbitrators. Is not affiliated with any state or any organizations. It is an impartial and independent arbitration center located in Ankara, capital city in Turkey, ensuring that the arbitration process is carried out objectively and reliably. The Energy Disputes Arbitration Center is home to board members, consultants, and arbitrators from different nationalities and legal systems who are expert in the energy sectors and international law.
Thank you so much. My next question to you is, how does the mediation system work in Turkey? From Pakistan, we think and believe that Turkey has done some really good work in mediation. So can you please enlighten us on what exactly is going on in mediation in Turkey?
So the mediation, so in Turkey there are two types of mediation we should mention. The first one is the optional mediation, or we can call voluntary mediation. But the other one is the conditions to the litigation mediation. So if mediation is decided as a case condition, parties filing a lawsuit without applying to a mediator will cause their cases to be rejected because of the lack of the case condition. For this reason, first of all, the parties apply to a mediation office for the mediation result. In Turkey, I should say not all cases covered by mediation. Mediation is only possible matter that the parties can decide with their free will. To put it clearly, the parties may go to mediation in matters that do not concern public order and are suitable for enforcement. Mediation is not possible in that matter the parties cannot contract, for example, in criminal cases, in civil registration cases, and also the cases related to the custody of children. I should say Turkey has made significant progress in mediation in recent years. For example, the law on mediation entered into force in Turkey 2013. At the beginning, mediation was applied only voluntary, then it was made a condition to be file a lawsuit for labor disputes in 2018. For commercial disputes in 2019, and finally for consumer disputes in 2020, and actually recently the mediation became a mandatory for the rental disputes in 2023. Actually, in this conference, also people ask me a lot about mediation because I know you just enacted the mediation act in Pakistan. Like mediation, people are asking like mediation is a commonly used alternative dispute mechanism in your jurisdiction. Also, in terms of commercial disputes, what proportion of the commercial disputes are settled through mediation? So if you look at the recent statistics, I can say the mediation, including voluntary mediation, is becoming more common and the mediation culture is now emerging in Turkey. Mediation is mandatory before filing a lawsuit in labor disputes in Turkey. This is like the debt and compensation claims arising from the law, individual and collective labor contract and re-employment claims. And also, since 2019, a mediation process for commercial disputes has also entered into force, with the mediation being mandatory in certain cases. With regard to commercial disputes, parties must first apply for the mediation for disputes relating to any claim for receivables and compensation in Turkish Commercial Code. Such as IP-related disputes, there is a mandatory mediation, banking and financial service disputes, disputes relating to recourse lending transactions, and disputes relating to publishing contracts, and disputes relating to business or assets, acquisitions, mergers, and reorganizations. I'm almost finishing. I just want to mention the statistic released by the Ministry of Justice recently shows that the disputes were referred to a voluntary mediation since 2013. The rate of settlement is about 99%. It is such a huge amount, and the statistic shows that the mediation really works in Turkey. The awareness of the culture of resolution in the country is increasing. The promising results suggest that the use of ADR and arbitration will also increase in the near future. Thank you for your time and attention. If we're all set.
No, thank you.